Hello, my name is Rishad Ahmed Chaudhry. I am a lawyer practicing in New Delhi and a partner with the law firm Various Advocates, and I'm also a doctoral or JSD candidate at the University of Chicago Law School. Today's lecture deals with a very important topic in constitutional law and particularly in comparative constitutional law, that of freedom of speech and expression. Today we are going to look at the issue of how this particular very important fundamental right of speech and expression is protected in different constitutions around the world. I am broadly going to now discuss the issues that are going to be dealt with in the present presentation. There are three broad issues that will be discussed in this presentation. One is the nature of the right to freedom of speech and expression, and what is the nature of the right, what is the extent, and broadly in what manner is it exercised in legal systems around the world. Secondly is the importance of the right. Why is this regarded as such a valuable right in constitutions all across the world? And I'm going to present a summarized version of three important theories of why this right is so important. The third section will discuss the limitations or the restrictions on the right in different constitutions or legal systems, and we'll briefly address why it is inevitable that the right will be not an absolute one but limited in one way or the other, and we'll try and deal with how different legal systems address or deal with the question of how and when to impose limitations on this right. The learning outcomes that would be expected if you have gone through this video would be as follows. One, it would be expected that you can broadly understand the nature of the right of freedom of speech and expression in different jurisdictions across the world. Again, not specifically with respect to the intricate details of each jurisdiction, but the broad and overall governing principles. Secondly, that you can broadly understand the types of speech expression, that is, what things are or are not regarded as speech, what things are or are not regarded as expression that is worthy of protection in different jurisdictions across the world. And thirdly, and very importantly for any exercise in comparative constitutional law, you would get a starting insight into what are the important differences that may arise in how and the extent to which different countries protect this right differently. That is, some countries extend broader protection, some more limited protection. Some countries are willing to tolerate restrictions or limitations on the right in question to an extent which would be unacceptable in other countries. And we would hopefully start to understand what are the underlying differences in the two in the legal systems in question that lead to these differences. At the outset, I'm just going to deal briefly with certain underlying philosophical justifications or foundations for this right. Now, the right to free speech and expression, as you all probably are aware, is one of the most widely protected rights in legal systems across the world. Probably alongside the right to life, it is an almost universal right that is protected in legal systems and constitutions across the world. And it is found in the Universal Declaration of Human Rights. It finds an important place in the Covenant on Civil and Political Rights. The question arises, why is this right to freedom of speech and expression so important? What makes it so critical to our idea of what is necessary to have a free human society? And there are, broadly, very simply speaking, three important philosophical arguments have been put forward by legal theorists and philosophers over the years as to why freedom of expression, why freedom of speech is so very important. One strain of thought or one strain of argument values or gives importance to the freedom of speech and expression for its capacity to further the search for truth or the right answer. And in this regard, what of course comes to mind immediately is John Stuart Mill and his famous treatise on liberty. And one of John Stuart Mill's main concerns or arguments was the intrinsic fallibility of human judgment. And all of us can think back to a time when it was taken to be received wisdom that the earth is flat, and the idea that the earth is round was regarded as simply a crazy notion. So John Stuart Mill takes this notion forward that human judgment, human insight is inherently fallible, and therefore one should be very, very cautious about limiting particular types of speech merely on the assumption that what they say is of no value or what they say is wrong. and what they say, we already know better. John Stuart Mill was very skeptical of this idea that we already know better, and therefore this entire strain of philosophical thought starting from John Stuart Mill values free speech for its capacity to promote our search for truth. The second strain, or the second set of philosophical arguments, value freedom of speech for a slightly different reason. They value freedom of speech or freedom of expression on the ground, broadly speaking, that in a sense it is intrinsic to being a human being, that and as an individual, having our own opinions, having our own views, having our own beliefs, acting in our own manner to further those views and opinions and beliefs, that is something very fundamental and intrinsic to, in fact, being a human being. And therefore, it is on considerations of autonomy, human dignity, that freedom of expression is such a very valuable and cherished human right. Now, the third important philosophical argument that I am coming to is an argument which is a slightly more instrumental argument, that is, it values free speech for what it helps us achieve, and this argument says that free speech helps us achieve democracy. This strain of philosophical thought says that democracy is intrinsic to human well-being. This is something which is fairly uncontroversial in the 21st century, and this strain of argument says that for democracy to be meaningful, for democracy to work well and to function in a manner which is not merely formal but really meaningful, it is essential that citizens have the capacity to hold their governments accountable, and the ability to effectively choose your government depends on the free flow of information. It depends, for example, on your ability to ask questions and to get answers, and to express your satisfaction or dissatisfaction with those answers. And therefore, the third philosophical argument basically says that freedom of speech is very important because it helps us to maintain and further our democratic form of government. So that concludes our discussion of the philosophical foundations or justifications for the very central place that is given to free speech and free expression in constitutions across the world. I will now come to two very important structural elements of this right. And by structural elements, what do I mean? I mean that the right is not given in a vacuum. It is given in a particular context, and we need certain structural or doctrinal tests to determine in any legal system, in any constitution across the world, to what extent that right extends and where it stops having sway. The two structural elements I'm going to cover here are: one, coverage and protection, and two, limitations on expression. So the first head of these two parts, that is coverage and protection, essentially goes to what is expression, what is speech. Now this might seem self-evident at first. It's obvious what speech is. Speaking in public, a political rally, that's what we commonly understand to be speech. But when you think about it a little more carefully, you realize that it's not all that obvious, and there is a particular place where the line gets blurred, and it is rather difficult to make out what constitutes speech. So, for example, certainly speech extends to speaking and writing, but what about non-linguistic forms of communication? What about artistic expression? What about painting? What about music? What about wearing a black armband, for example, to protest something? What about wearing a T-shirt with a particular message on it? What about other forms of expressive conduct? What about the very, very important issue in different parts of the world in the context of this fundamental right of flag burning? What if somebody wanted to burn a flag to express their dissatisfaction with their country's conduct in some particular realm of policy? How would that be viewed? So all these questions go to the first leg of my structural part of my presentation, which is the extent of coverage. Now, broadly speaking, in different legal jurisdictions across the world, the terms speech and expression are given a fairly wide and broad sort of coverage, in the sense that it is understood that there are many forms of expressive conduct, like flag burning. I referred to earlier, which can express your thoughts, can express your emotions, can express or convey what you wish to convey to your fellow citizens, to the government, more effectively, or at least as effectively as any other forms of written or spoken communication. And therefore, it is logical, if we think that this right of free speech is a valuable right, that these other forms of expressive conduct should be protected too. So broadly speaking, the right to free speech in different legal systems across the world defines speech and expression very broadly to include most forms of artistic expression and other forms of non-linguistic but expressive conduct. For example, the wearing of a protest band, the wearing of a t-shirt with a message. The refusal to speak in certain cases can be very significant indeed, and the refusal to speak has in fact been considered to in itself constitute a form of constitutionally protected speech. I now move to the second structural aspect of the fundamental right to free speech and expression in different jurisdictions across the world, which is a very, very important aspect of limitations. Now, it is very important, and please bear in mind, that the first aspect of coverage merely indicates, it could be put this way, that coverage merely indicates that the conduct in question is potentially, or let us say presumptively, entitled to some protection. But this doesn't answer the question of whether there are other countervailing interests, other rights, other good reasons in law why that speech, which would otherwise be protected speech, might nonetheless need to be restricted, perhaps for reasons of wider public interest, perhaps to contain violence, perhaps to prevent defamation for such reasons. So now whether speech, which is constitutionally protected speech, might constitutionally be restricted for certain valid and good reasons is what is considered in the second part, which is limitations on expressions. Now, how are limitations on expressions determined in different jurisdictions across the world? Again, at the risk of oversimplifying slightly, there are broadly perhaps two approaches to how the fundamental right or the legal right of free expression can be limited. And one is what is generally known as an absolutist or a categorical approach to such limitation, and the other approach is a balancing approach. Now, the categorical approach, and the United States of America is probably a good example of a categorical approach. The categorical approach tries to have clear-cut rules and sort of, let's say, boxes into which different classes of speech can be put, and the level of protection and the reasons for which such protection can be withdrawn are defined in fairly rigid and inflexible terms in such jurisdictions. So let me give an example from the US context. Political speech is a particular category of speech. Political speech in the US is given perhaps the highest value of all, and it can be restricted for almost no reasons at all, except something like the imminent threat of violence being caused by that speech, or a situation where the speech is considered something which is known as fighting words in US constitutional law doctrine. On the other hand, jurisdictions like Canada, for example, which follow a different approach, think that the categorical or the absolutist approach might not give you enough flexibility to take into account all the various aspects that you need to weigh the competing interests and the competing rights in question, and to take a final and a sort of fully informed decision in that regard. And so these other jurisdictions rely on something which is called the balancing approach. Now, balancing, of course, varies widely in the various jurisdictions which adhere to it, but broadly speaking, one can understand a balancing approach by saying that we do not have absolute rules defining what category of speech or what type of speech is entitled to what level of protection, but rather we weigh. What we do is we weigh the competing interests and the competing claims at hand. So we look at the extent of the restriction on speech, we look at the importance of the speech being restricted on the one hand, and on the other hand we look at the reason or the necessity of the restriction, and also whether the extent of the restriction conforms to the need of the hour. So in other words, you could think of a situation where the court agrees with the government that there is some reason to restrict a particular type of speech, say in times of war, but thinks that the amount of restriction is overbroad. So the government might want to restrict a large class of speech, and the court might come to the conclusion that, well, yes, on our balancing approach, we see that the government does have a particular interest in restricting speech, but that the amount of speech restricted is overbroad, and only these categories of really, really critical information, perhaps relating to national security considerations, should actually be allowed to be restricted. So again, coming back to the two broad categories, I should say these are not clear-cut or watertight categories. This is more to understand the broad distinctions at hand, but it should be understood that different countries in various areas of constitutional law, and particularly in the area of free speech and expression, rely on rules versus standards, or in this case rules versus balancing to various extents. The rule-based approach, which is, as I said, to some extent very common to US First Amendment law, US free speech law, has its advantages in that it enables clear-cut answers, but sometimes it can lead to difficult situations too. Now, coming to US law, a minute ago I mentioned First Amendment. Now, the reason I said First Amendment is the First Amendment is that provision of the US Constitution which protects free speech. Now, what the First Amendment to the US Constitution says is, and I quote, "Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble." Now, you would see right at the outset that this is phrased in fairly broad and absolute terms. In fact, there was a famous judge of the US Supreme Court who said that Congress shall make no law means just that, Congress shall make no law. And what he meant is that the right to freedom of speech and expression in the US is an absolute right. Now, that's not quite the case here, as we'll see, because intrinsically anywhere in the world, all of us can understand no right can be absolute. Every right has to yield somewhere, to some extent or the other, to societal interests or to a broader sort of community interests. But it is certainly true that in the US, the right to free speech is restricted very sparingly, and most of all in the realm of, as I said earlier, political speech or other speech of that public nature. As I said, the kind of speech, that is whether it is political speech or whether it is private speech, is one significant factor. Another factor which is very significant in the realm of US First Amendment law is the concept of viewpoint neutrality. Now, to understand viewpoint neutrality, we have to understand, viewpoint neutrality, speech doctrine in the US is very, very suspicious of a particular viewpoint being privileged over all other competing viewpoints, and this is true no matter how commonsensically correct one of the views might be. So, for example, all of us might assume that it's quite right not to, for the state to restrict particular viewpoints just because they don't like it, and that therefore viewpoint neutrality as a principle of constitutional law is commonsensically correct. But one has to bear in mind that while this principle may have value, it can present challenges too. So, for example, in the US, viewpoint neutrality means that absent certain narrow examples which I have referred to earlier, such as the likelihood of imminent violation, the government cannot restrict speech no matter how hateful it is, no matter how regressive it is, no matter how contrary to other constitutional values it might be. So, to take an example, racial equality is a very important principle of the US Constitution today, as it is of most constitutions across the world. But First Amendment doctrine in the US is very clear on the fact that even racist speech, even speech propagating, let's say, crude gender stereotypes, is entitled to the same constitutional protection as all other political speech, save and except, again, as I said, certain very, very narrowly drawn exceptions where the courts are convinced that that speech cannot be restricted without grave and imminent risk of violence or legal sort of injury to a particular person. So this is sort of a bird's eye view of US First Amendment doctrine. There are two important cases I will just briefly flag to give you an idea of what I meant when I said that US First Amendment doctrine is very broad indeed, is very absolute rather. One of these cases is the famous recent case of Citizens United versus the Federal Election Commission. Now the Citizens United case is a case which has actually made headlines around the world, because what it says is basically a narrow majority in a closely divided US Supreme Court essentially held that the restrictions in campaign finance law in the United States of America, which prohibited corporations from independently spending money to propagate their viewpoint in elections. So what the US Supreme Court said is that such expenditure is also a form of speech, because it's a form of furthering your point of view, and that the absolute restriction or the prohibition on US corporations from engaging in such expenditure to independently propagate their point of view during elections is in fact unconstitutional. And in the latest presidential elections in 2012, this in fact had a very important practical effect, because one saw US corporations spending huge amounts of money for one side or the other, propagating their respective political views or their views on important issues of the day. And critics of this decision have said that this decision artificially and unrealistically sort of conflates legal persons, that is corporations, with natural persons. And critics have said that legal persons like corporations simply, in the very nature of things, are not entitled to the protection of this constitutional right to the same extent as natural persons. And critics have also said that the philosophical justifications, which perhaps I referred to a while ago, do not really apply with the same force to corporations as they do to individual human beings. Be that as it may, that is the law in the US today. The second case, which I'm going to briefly advert to, is the case of Snyder versus Phelps, again a US Supreme Court decision. In the case of Snyder versus Phelps in the US Supreme Court, what happened is that this particular family actually belonged to a particular sort of religious group in the United States, which had rather strong and, let's say, controversial views about many contemporary issues in the United States, and particularly they believed that the United States decriminalizing homosexuality, etc., was a very great sin according to this particular religious community, and therefore they wanted to express their strong displeasure in rather provocative terms at this sort of action on the part of the broader sort of US polity. And what therefore this community did is they essentially picketed. They've been doing this for many years, but this is a particular case that came up to the US Supreme Court. They picketed various sensitive public events, and in fact they went to the extent of picketing the funeral of a US soldier who had been killed in Iraq. And while picketing his funeral, in fact they held up peacefully, they did not indulge in any violence, but they peacefully held up certain signs which held slogans and messages which would be very hurtful for most neutral observers, and particularly for the family of the US soldier who'd been killed, because their messages read to the effect that thank God for dead soldiers, etc., etc., and implying that this was inevitable as long as the US sort of lived in sin. And this case went up to the US Supreme Court because the family of this soldier who had been killed, who were naturally devastated by this picketing of the funeral, they went to a civil court claiming damages for infliction of emotional distress. And initially they won before a jury and obtained substantial damages, but an appellate court held that the speech in question, the sign, as we discussed, holding a sign is expressive speech. So they held that the conduct indulged in by this particular religious community, while horribly offensive, was protected speech and therefore protected by the First Amendment. And the US Supreme Court in fact finally agreed with this appellate court and held that while extremely hurtful, the speech was constitutionally protected, and since it was constitutionally protected speech, therefore the persons in question had done no legal wrong, and therefore the family of the soldier was not entitled to claim damages from that family. So this is just to help one understand that all approaches to freedom of speech and expression present their own challenges, and while the US is a robust and free society which in fact does have an exemplary commitment to free public discourse, this poses challenges too, such as in the election case, where one wonders whether free speech sometimes is not in a manner almost being drowned out by unlimited contributions from almost anonymous corporate entities at the expense perhaps of humbler voices. Now I will turn, after our experiment or our survey of the US experiment, I will now turn to something closer to home, which is the Indian scenario. Now India, as most of you would know, has a written constitution with enumerated fundamental rights in part 3 of the constitution. The right to freedom of speech and expression is particularly enumerated in article 19(1)(a) of the constitution, which states that all citizens shall have the right to freedom of speech and expression. Article 19 of the constitution in itself contains also the permissible constitutional restrictions on this right to free speech and expression. So article 19(2), which contains the relevant restrictions for our purpose, states that the right in question, and I quote, shall not prevent the state from imposing reasonable restrictions by law in the interests of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. Now most of these restrictions to many of us would seem commonsensical to an extent, but again the legal challenge comes in deciding when a restriction is overbroad and when a restriction is reasonably related to the purpose for which it is claimed. Because there's one thing I want you to note, which is in a sense jumps out at you from article 19(2), which is that the state is not prevented from imposing quote unquote reasonable restrictions. So not any restriction, but a reasonable restriction is what is prohibited. So there may well be restrictions at times which the courts conclude are overbroad or for other reasons unreasonable. I am now going to briefly take you through 3 Indian cases, and again this is mainly just to demonstrate the kinds of issues that come up before the courts in relation to free speech and expression, and also to demonstrate that how courts deal with these issues is not always very clear, as in even lawyers or legal experts would not always be able to predict how a court might come out on a given issue, and courts themselves, depending on which particular bench happens to be hearing a controversial matter, might well come out differently. So it's in some senses it's a chancy business. The first case I want to refer to is a very well-known case by the name of Bijoy Emmanuel versus State of Kerala. Now in this case, basically 3 students belonging to a particular religious community, which is known as the Jehovah Witnesses, which is a religious community across the world, and this community has certain very particular religious beliefs. Now these 3 young students were essentially expelled from their school in the state of Kerala. Now why were they expelled? They were expelled because they refused to take part in the singing of the national anthem, Jana Gana Mana. Essentially these students stood up when the national anthem was being sung, but they said, and their parents also said, that according to them this constituted a form of worship in their religious tradition, and they therefore were unwilling to address such a national anthem to anyone but God in that sense. You might be interested to know this is not an issue which has come up only in India. This particular legal controversy in relation to this belief of the Jehovah Witnesses is been litigated in constitutional courts across the world. But in India, what happened is that the Supreme Court essentially took the case where these students went to court saying that they were wrongly expelled and that their constitutional rights were therefore violated, and in particular their right, 1, to freedom of religion, and 2, their right to freedom of speech and expression. And the Supreme Court in fact agreed with these students, and they said that refusing to participate in something or refusing to speak, as I said earlier, is also a form of speech, and that the Kerala government had not imposed this restriction through a properly enacted law, but it was just an ad hoc government circular which sort of was relied upon to expel these students, and therefore the action of the school in expelling these students was set aside and invalidated. And this is regarded as one of the most pro-free speech cases ever pronounced by the Indian Supreme Court, and the judgment was authored by a very sort of distinguished judge of the Indian Supreme Court by the name of Justice Chinnappa Reddy. The second case I want to now come to is a case in the context of the ban being imposed on a particular book. The name of this case is Baragur Ramachandrappa. Now, in this case, what happened is there was a work of fiction, but this work of fiction drew from a particular series of historical incidents in the medieval period in Indian history, dealing with two very well respected and sort of venerated, let me say, saints in the area in South India, which is now in Karnataka. So these saints were venerated, and they are essentially regarded today as divine figures. This work of fiction was by a scholar who had studied this particular period in Indian history very, very closely, and it was, in a sense, he was a person with deep knowledge of the issue. But this work was a work of fiction in the sense he used certain real life incidents, and he incorporated other elements which were fictional, and drew a work of fiction which took place in that period in medieval Indian history. And the allegation was that he related certain incidents in such a manner that it suggested some moral turpitude on the part of the sort of two persons, the saints in question, and therefore this hurt the sentiments of the followers of that particular religious sect, and this sect complained to the government authorities. The work of fiction was in fact banned. That ban was challenged in the High Court of Karnataka, and the appeal finally came to the Supreme Court, and the Indian Supreme Court in fact upheld that ban. And what the Supreme Court said is that, look, yes, the right to freedom of speech and expression is a very wide right, it's a very important right, it's a cherished fundamental freedom, but it said that in this case the author had deliberately and provocatively written something which he knew or ought to have known would severely offend the sentiments of a set of his fellow citizens, and they said that the court should be cognizant of the sentiments of all sections of society, including segments of the society which are perhaps not numerically powerful. And on that reasoning, the Indian Supreme Court upheld the ban on this book. Now, you might look at the first case I pointed out and the second case, and you might think, as many people have done, that there is a degree of inconsistency between these cases, and very arguably that is so, because even in the first case, people might well be rather offended by the failure of someone to sing the national anthem, but the court took a very sort of individual, almost a sort of a libertarian view of the matter, and said that mere offense is not enough to take away somebody's constitutional rights and freedoms. The third and last case I'm going to come to in the Indian context is the case of a well-known actress, a well-known Indian actress actually, by the name of Khushbu. Now, in this case, what happened is that this actress gave an interview to a particular print magazine, and in that interview, among the various other things she may have spoken about, she commented rather that there is an increasing incidence of the practice of premarital sex, or youngsters engaging in sex before marriage at the time in contemporary times. And she also expressed her personal view that this is a personal choice and there's nothing really wrong with it. Now, again, certain individuals residing in that part of the country, in the state of Tamil Nadu, thought this was very offensive and defamatory, in the sense that it imputed a particular form of conduct to the people of Tamil Nadu, and particularly to the women of Tamil Nadu, that they at least regarded as immoral. And therefore, these persons filed certain criminal complaints against this actress. This actress then approached the relevant courts for quashing of those criminal complaints at a preliminary stage. Now, it's important to note that she didn't want to await the trial process. She was making a legal argument that these allegations are clearly so perverse and so contrary to her constitutional right to free speech that the case should be quashed at the outset before a trial. Now, this case found its way going up to the Supreme Court, and finally, eventually, the Indian Supreme Court agreed with this actress, agreed with Khushbu. And what the Supreme Court said is that, look, notions of societal morality are inherently subjective in character, and one person's saint is another's sinner. And the court said and cautioned that the law ought not to be employed in a manner that will have a chilling effect on free expression. And therefore, the court accepted the prayer made by this particular individual and quashed the criminal cases pending against her. So this again is another case of the Indian Supreme Court taking a relatively pro-free speech approach. And it's interesting to see that these variations and these permutations and combinations keep coming up in case law, and therefore the constitutional doctrine perhaps is not as coherent as one might like it to be. Now, in conclusion, I have gone through this presentation trying to emphasize the fact that the right to free speech and expression is regarded as a very important one and is found in perhaps most of the legal systems of the world. Having said that, no right is absolute, and the right to freedom of speech and expression is not absolute either. The question of how and when to impose restrictions and limitations on this right is a complex and frankly a not too easy to answer question. We've gone through certain hard cases, to put it that way, which have arisen in both the United States of America as well as in India, to see that it's not always easy to see where the right starts and where the right ends, and where reasonable and permissible restrictions should be imposed and should not be imposed. And the idea of surveying this set of hard cases in the United States and India was not in any way to suggest that it's a comprehensive survey of the law, but rather just to give you a pointer of the sorts of challenges that courts, and in particular the constitutional courts in any country, have to deal with when they confront questions of the exercise of this particular very important fundamental right. Thank you.